Welcome to Case by Case. This is a podcast series brought to you by Luke Zadkovich, that's me, and Calum Cheyne. How are you, Calum?
That's me. I'm good. How are you, Luke?
Good. Hey, I'm interested for today. I'm looking forward to it. This is a different, well, same but different, if you know what I mean.
We're going back into the archives.
We're going right back to 1961. And there's a reason. There's a reason why we're going back into the archives. I'm actually teaching a university course at my alma mater at the University of Wollongong out in Australia in a few weeks. And as a part of preparing for the course, I've had to read some of the materials that the students are going to have to read, this case being one of them. So I thought, what better way to prepare than get my fellow podcaster to read the case with me, and we chat about it. And so that's what we're going to do.
It's a sneak preview for the students as well. They can come on and be top of the class having listened to us talk through these cases.
There you go. I think what I should do is not tell anyone that we've done the podcast on cases that are in the course and see who's just been following the podcast. So if you're a student and you have heard this in the course, let me know. Straight to the head of the class. No, I'm joking. Okay, right. So what case are we talking about today? We're talking about a case, I think, with a great name. It's a really good name for what we're about to talk about. The case is called Mash and Murrell Ltd v. Joseph Emmanuel Ltd. Both traders of potatoes. Well, they were once upon a time. I think they called them dealers back in the 60s, but they were effectively commodity traders. And the commodity that was being shipped in this particular trade, or being bought and sold in this commodity trade, was potatoes. And here I am thinking, when mash was mentioned in the name of a potato trader, that would have something to do with the potatoes. No, it's a Mr. Mash. Mr. Mash is, or was, the director of a company that bought and sold potatoes. And guess what happened to the potatoes? Pretty much ended up in some poor mash that ended up being sold off to pigs for pig mash.
So I looked up these the types of potatoes, the Cyprus spring potatoes, but they're not so good for mash. I checked that.
Oh, really? Okay.
It's not the ideal way to cook a Cyprus spring potato.
See, what I like about you, Calum, is that we've done so many of these things now that you know my bad dad jokes that are coming, and you now are second guessing my jokes.
doing the due diligence on the jokes before they come.
Due diligence, exactly. Right. So, well, look, it's a good case because what we're going to get into is looking at implied terms in sale of goods contracts. We're going to look at it from an English perspective, and I think it's really important from the outset to keep in mind the history of sale of goods law in England. And if we go back to before 1890 odd, we were dealing with the common law for these types of issues. We were dealing with whether a term might be implied as to the merchantability of goods into a contract, so that there's this common understanding between seller and buyer as to what state or what quality the goods will have, even if the contract doesn't mention anything about the quality expressly. So before, in the 19th century, until right at the end, until the first edition of the Sale of Goods Act came into being, we were dealing with the common law. Then we had the first Sale of Goods Act, and that codified some of these common law principles. And that's what we're going to be looking at today, a case that then came much later in the 1960s that's looking at what was then in place, the Sale of Goods Act as it was then. And we'll get into that. But the principles that were discussed in this case of Mash and Emmanuel are still relevant today, even though there have been subsequent revisions of that Sale of Goods Act. And so keeping the history and the kind of origin and the progression of the Sale of Goods law is important. The actual principle we're going to talk about today is still relevant to today, even though we've got a different Sale of Goods Act to deal with.
Yeah, exactly. And there's also an interesting procedural point here, which is that we're looking at a High Court case, which was ultimately overturned on appeal. But it's the High Court case that has the legal position that endures and which is of interest. The appeal, and I'm not quite sure how this worked, but the appeal overturned the High Court decision on the basis of a different fact pattern, which I found interesting in the context of a podcast we did a few weeks ago, Luke, where in that case the Court of Appeal expressly said that that their ability to make a decision was fettered by the High Court making findings on facts and the arbitrators making findings on facts. I don't know exactly what the difference was between these situations, whether there's new law going on there. I'm sure there's maybe some keen-eared listeners will explain the difference to me. But in this case, it's the High Court decision that we're interested in, and it's the High Court decision which is the kind of legal principle.
Yeah, it seems back to front, doesn't it? It's usually you're stuck with the facts at first instance, and then you go to the Court of Appeal to turn the law over. Whereas here they've got the law sorted at first instance, and then gone to the Court of Appeal to reverse the facts, and they've done so successfully. So it got me tied up. I was like, hang on, we've focused on this first instance case, which is what's referred to in the publications and subsequent cases, but actually it went on appeal. So yeah, interesting one. I haven't focused on that for the purposes of today's podcast, but I'd be interested to know how that worked procedurally. But also, again, one point, and I won't get into this too much, it was interesting reading through the case we are going to discuss today, the first instance decision before Diplock, justice as he then was, in that counsel for the defendant really seemed to go large on arguing the law at first instance. And it didn't seem to be argued all that much, at least from the judgment itself, that the facts were in dispute. And there was this interesting evidential point that I picked up as I read through a Calum, where the claimants hadn't led expert evidence, but the respondents had led expert evidence. And it didn't seem like that was really focused on in the judgment. And I just wondered whether that may have been part of it, is whether the judgment was more focused on the law and resolving a legal question for some reason, and the factual aspects were not delved into in the way that we might expect. I don't know, but it seemed a little strange to me.
I found that slightly odd that expert evidence was only led on one side, and there's no real explanation for it in the judgment. And the judge didn't really look into the facts in a huge amount of detail on why the potatoes became rotten. So we don't, and to be honest, for our purposes and for the purposes of our listeners, some 65 years on, I don't think we really care why in this case the potatoes became rotten.
We don't. But it's important to note that the legal principles we're going to talk about were on the basis. So we're talking about some potatoes that were shipped from Cyprus to England. The facts don't really matter all that much. But the question is, and we're going to talk about the nature of the implied term by the Sale of Goods Act as to, well, at this time it was merchantability, but in these days we use the phrase satisfactory quality, which is in the latest Sale of Goods Act. But we'll talk about that and unpack it. But the question is all about when the seller puts those goods on board the ship, do the goods need to be in merchantable quality as at the time of putting the goods on board the vessel, so that the time of actual delivery and when risk passes? Or do the goods need to be able to withstand an ordinary carriage through to where they're intended to be delivered? And so we're not talking about cargo damage claims here. That's a different type of claim. And if you are the receiver, the buyer here, and you had a problem that arose during the voyage, you would presumably look to the carrier for a problem that happened during the voyage while you're on risk. We're not talking about that topic today. What we're talking about is the sale contract between seller and buyer, and what is the quality of the goods that the buyer is buying. And do those goods need to withstand an ordinary voyage in this case, from Cyprus to England, such that when the potatoes get to England, that they're still in merchantable state. And so it's not just to withstand the voyage, it's also for a reasonable time thereafter to be sold as goods that are fit for human consumption.
Yeah, and if you're the seller in this context, you would be saying, no way. I'm selling you goods and I'm placing them on board a vessel, and those are my obligations finished. So when I have an obligation in the contract as to the merchantability of these goods or the fitness for the purpose of these goods, those implied terms are only insofar as the goods are put on board the ship. And if you're the buyer, you're saying, no, in order to be fit for purpose, or in order to be merchantable, they have to be merchantable on discharge, or fit for purpose on discharge. And the buyer's not going as far as saying they have to be merchantable on discharge, no matter what, come what may, because there is an understanding that the buyer has some risk during transit. However, the buyer is saying, in ordinary circumstances, if this voyage is performed in an ordinary way, then your obligation to give me merchantable goods means that they have to be merchantable on receipt at the disport.
Yeah, and I think it is useful just to look at very briefly what happened in the appeal case to kind of make the point. Well, factually, what ultimately was decided here was that there was a problem during the voyage, that it wasn't an ordinary voyage, and that the potatoes weren't ventilated during loading properly. That was the factual decision, ironically, at Court of Appeal level, not in this case, in this first instance decision. In the first instance decision, they said that the cargo was subject to an ordinary voyage. There wasn't a problem, or at least it was presumed that it was an ordinary voyage. And so when you identify that, where you kind of focus on the factual differences, you can see what we're talking about. If something were to happen to the cargo during the voyage, that's different. That's a different category. It's something else. What we're talking about is the goods, if they're just subjected to a normal, ordinary voyage, do they still have to be in the quality that's being warranted on an implied basis on actual physical delivery onto the ship? And does it need to be the same when it gets to the other end, and for a reasonable period of time to be able to sell the products into the market? And so the place to start on this question is on the version of the Sale of Goods Act that was in place at the time, and that was the 1893 version. And we're looking at sections 14, sub 1, sub 2. And it was argued on three bases by the plaintiff. One, on section 14.1, on section 14.2, and also as a residual type allegation based on the common law. And it was interesting, I thought, that, Calum, that they still had the pre-1893 common law argument there as well as a kind of catch-all if it's not caught by sections 14.1 and 2.
Yeah, I agree. I thought that was interesting, and it was interesting how it was treated by the judges as all really being the same question.
There was a great phrase in this, actually, which I'll pull up if I can find it quickly. Oh, here it was, yeah. So he basically said that section 14.1 and section 14.2 were two sides of the same coin. And let's talk about each of those in a second. But then he went on to talk about this line. If it were possible for the coin to have three sides, I should say that the implied term being argued under common law is effectively another side of that coin. So I thought that was a neat line. And this was actually I saw that this case was before Diplock when he was a justice sitting on the Queen's bench. And this was his last year before he was appointed as a Lord to the Court of Appeal. Interesting. Should we go through section 14.1 and then section 14.2? So this is at that time. I'll read them out. Why don't I deal first with section 14.1 and we'll talk about that for a moment. So this is the Sale of Goods Act 1893 being looked at in the 1960s. Section 14.1, where the buyer, expressly or by implication, makes known to the seller the particular purpose for which the goods are required, so as to show that the buyer relies on the seller's skill or judgment, and the goods are of a description which it is in the course of the seller's business to supply, whether he be the manufacturer or not. There is an implied condition that the goods shall be reasonably fit for such purpose. And then 2 is where goods are bought by description from a seller who deals in goods of that description, whether he be the manufacturer or not, there is an implied condition that the goods shall be of merchantable quality. So you've got these 2 different types of implied terms here. One is about knowledge of the seller and whether the buyer tells the seller what the particular purpose will be for these goods, and this concept of reliance, that there's reliance upon the seller's skill and judgment. And then there's this second one about, well, if the buyer does not tell the seller what the particular purpose will be for those goods, what should be implied as a matter of, let's say, common knowledge or industry understanding? Is it clear that potatoes for human consumption means that they have to be of a certain quality to be eaten at the other end? So it's more of a broad industry understanding, custom type implied term.
Yeah, exactly. And I was quite interested to see how this tracked through to the modern day Sale of Goods Act. So I had a look at Sale of Goods Act 1979, which is the latest iteration, and you have the implied terms there at section 14. Section 14, subsection 2 says that where the seller sells goods in the course of business, there is an implied terms that the goods supplied under the contract are of satisfactory quality. And satisfactory quality is then set out in section 14, subsection 2b, where it talks about the first thing it says is that in order to be of satisfactory quality, the goods have to have fitness for all the purposes which the goods of the kind in question are commonly supplied. And interestingly, at 14, subsection 3, it talks about the situation that you were talking about there, Luke. It says, where the seller sells goods in the course of the business, and the buyer expressly or by implication makes known to the seller any particular purpose for which the goods are being bought, there's an implied term that the goods supplied under the contract are reasonably fit for that purpose. And in this case, in our case, a similar test would apply. And the buyer was saying there, well, that we're going to sell these for human consumption. And therefore they have to arrive in a condition where we can sell them for human consumption. Otherwise, they're not in the condition that they're supposed to be in for us to accept the goods. So that was really where the case turned. The High Court said they agreed with the buyer, and they said, if you're selling goods and the purpose for these goods, and that can be made out on a number of different evidential grounds. For example, if you're a buyer in this situation, you can say, well, we've traded with you in the past, and you know what we do. You know how our business operates. So that we made that purpose known to you by implication. Or it can be expressed. You can say, well, you can say in the contract, we're going to use these goods to sell them to sell potatoes in Liverpool. But as long as the seller knows the reason why the buyer is buying the goods, then the goods have to be fit for that purpose. In order to be fit for that purpose, the High Court quite sensibly held that the goods had to be in a condition on delivery, i.e. when they were put on board the ship, that meant that they could survive the voyage and still be fit for the sales purpose. So the purpose of the goods were selling them at the end of a voyage, not selling them at the start of a voyage, if that makes sense.
That does make sense. Exactly. And one of the, I suppose one of the leading decisions on this issue at the time was the Beer and Walker case, which was not about beer. And I'm struggling to equate beer with the product in that case. But it was all about rabbits.
The famous rabbits case, as they called it.
And what I didn't immediately, I couldn't immediately work out from this was whether in what form the rabbits were. It's like how do you refer to rabbit meat, for example? Like, is that what you call rabbits? Do you call that rabbits, or were these actual rabbits?
It's not like beef or pork where you have the name of the animal and then the name of the meat. It's just, but also they don't refer to rabbit meat. They refer to the rabbits, which when I first read it, I was thinking they must be talking about living rabbits, but I'm pretty sure they were talking about the carcasses of rabbits.
I know I don't know how we got onto this, but this is what it says. That was a case of rabbits being sent from London to Brighton. The rabbits were of merchantable quality, that is to say, fit for human consumption, when they were sent from London. But when they were delivered to the defendants in Brighton, they were putrid and valueless.
Yeah, I liked the just in the context of that slight tangent, the Deputy County Court judge said, when the rabbits were sent from London, they were in good order and condition. And I suppose that depends on whether you ask the rabbit or not.
Well, exactly. Yeah, I had a little chuckle about that. Poor rabbits. Right. So that case was about to whom does the loss fall, as it was put. So there was no issue in that case that the rabbits were in good quality, they were merchantable, they were fit for human consumption when they were put on board the train in London, but then they get to the other end and they're no longer in good order and condition. And so the question is, well, what has happened during the voyage? Why is have the rabbits become valueless and putrid? Was it because of something that happened that's out of the ordinary during the voyage, or was there a problem with them from the outset and they weren't in a state to withstand that voyage, such that when they get to the other end, they're not going to be fit for human consumption?
Yeah, and in the county court in that case, in the divisional court in Brighton, I believe, the deputy county court judge said, "I'm of the opinion that that condition, which is a reference to the merchantable condition, was satisfied if the rabbits were delivered in good order and condition to the railway in London." So they effectively were saying, if you can get to the point of discharge, then you satisfied what you need to do as the seller. But this case then went to the
point of discharge, or the point of
the point of loading. So in this case, the rabbits were being sent from London, and in the divisional court, the deputy county court judge said, "I think that as long as the sellers can get these rabbits to the point of loading, then they satisfy their requirement." But it then got appealed. And on appeal, the judge said, "I'm of the opinion that the implied warranty extended to the time at which, in the ordinary course of transit, the rabbits should reach the defendant, and not only to that time, but that it continued until the defendant should have a reasonable opportunity of dealing with them in the ordinary course of business. So the court there was saying, well, if you're buying rabbits to sell, you have to have the opportunity to sell them at the other end.
Yeah, it's kind of like, what's the point of the contract? What's the point? What's the point of the deal if, as a buyer, you're buying goods that by the time they get to you are of no good? Now, if something happens to them, if someone doesn't look after them and you're at risk, then okay, you've got a claim against the carrier. Fair enough. But between seller and buyer, you can understand why this implied warranty exists. And at this point in time, this was before the Sale of Goods Act. So this was before 1893, this Beer and Walker case. And so what we're looking at is the common law principle of merchantable quality, which was then codified in 1893 in the Sale of Goods Act. That was the subject of the Mash case.
Do you think you'd still get this implied term on the current Marks and Spencer's test? Is it either so obvious that it goes without saying? I'd say maybe, but not necessarily. Or alternatively, is it necessary to give business efficacy to the contract? And there, I think you probably get home.
Probably, I think you probably do still get home on it. It's an abstract question in a way, because there's been so much that has happened since that time on this law. There's been codifications of it. And look, one point that's worth making on this, Calum, is that we regularly see statutory implied terms excluded from contracts. That's commonly done. And that may be the common law implied terms, or it may be what's been codified by the Sale of Goods Act. And the parties then say, well, whatever's written in this contract expressly, those are the only warranties or conditions that you're going to get as to the quality of the goods. And so rather than leave it to the law, it's going to be set out by the parties in their contracts. I think you probably do still get it, because, as I say, I don't see how the contract makes sense where it's a contract that contemplates carriage of those goods to somewhere else. And if you're a seller and you're agreeing to a contract excluding these types of protection. If you're a buyer and you're agreeing to excluding these types of protections that you get, you want to make sure that you have pretty good, clear, express terms that allow you and ensure that you do get those goods in a decent state at the end of the voyage.
Yeah, and in the modern context, we'd be talking about a FOB or a CIF buyer there.
Exactly. I also wanted to note that there were a number of other cases that were cited in support of the position, which the judge looked to and relied upon. But really, it was the Beer and Walker decision that was the main one. But I like this line, and I wanted to emphasise this just in case that there are some Australian students who have listened into this podcast before the course. And I'll just read this out verbatim. Against those authorities, Mr. Roskill relies on a decision of the High Court of Australia, Bowden Brothers and Co. Limited v. Little. I greatly welcome the citation of Australian and other Commonwealth cases, particularly in a commercial court, where great assistance can be derived from seeing the way in which other great common law courts have dealt with analogous problems. Remembering this is back in a time when the legal systems were completely connected, and an appeal from the Australian courts went to the Privy Council. But I love that line. I thought it was a great line. As it turns out, the decision in Bowden Brothers wasn't all that helpful, I think. And the judge noted that at that time, there was still juries sitting on first instance decisions. Also noted that they had a pre-Judicature Act system of pleading, which kind of meant that the pleadings were very important in terms of what were the issues before the courts. And it seemed to be that case was kind of confined in some way. And in any event, it didn't really answer the question that was before the court in the Mash and Murrell case. But still, I thought that was a nice little shout out for Australian cases.
And actually, it's still true many years on that you can sometimes find support for, if you're in an untested area of law, then you can find support for your arguments in other Commonwealth jurisdictions. Yeah, it was only a couple of weeks ago that we were looking at a Canadian case that was being cited in an English Court of Appeal decision, or maybe it was an English High Court decision. Can't remember. It was one of the two. But the arguments
the zone of privacy one. Was
exactly,
that the zone of privacy?
Exactly, the zone of privacy. I think it was the Court of Appeal.
Oh, what if that was a males? It was a males case. So it must have been a Court of Appeal, right?
Yeah. So even today, people are still looking to other Commonwealth jurisdictions, and it's I guess one of the benefits of working at ZFZ. Actually, we have a number of people from different jurisdictions. We've got our US colleagues and we've got our Australian colleagues, and it is informative and instructive often to run legal issues by people in different jurisdictions to see how their jurisdiction would understand it.
Yeah, exactly. And so, look, in this case, the ultimate view of the judge and the court, which stood the test of time and has been a